If the prosecution is saying, well, we found a fiber at the crime scene that could have come from a shirt that Echols' little brother had, or it could have come from any other shirt in Walmart, and you compare that on the one hand to a scientific percentage that limits it down to a relatively small number of people, one of whom had the opportunity, as John said, was in the area, without indicting Terry Hobbs, a reasonable jury is not going to say that's proof beyond a reasonable doubt as far as Damien Echols is concerned. And you add it to what the grapefruit experiment of prosecutors saying, I have demonstrated to you that these marks are on the body of Chris Byers. It was just rubbish. It was absolute, unmitigated rubbish, that experiment.
So is evidence in mentioning Terry Hobbs in and of himself, or is that mentioned to show the innocence of Damien Echols?
Look, unlike other theories, maybe so-and-so, maybe a family member, they're a bad guy, they've got a drug history. All we know is that a report arrives from a scientific lab that says your client has no evidence at the crime scene. We have located someone who's consistent. By the way, that someone who's consistent is someone who certainly was in the area. I mean, do we not present that? Is that not a compelling argument for a judge trying to decide if Echols would be convicted? I'm just telling you that absent the kind of prejudice that was generated in 1993, a competent trial lawyer could not lose Damien Echols' case today, because there's not a single piece of credible evidence that connects him to the scene, and anything that they say is credible is far outweighed by things that could point in other directions. No reasonable juror would find guilt beyond a reasonable doubt. Conversely, any reasonable juror, in this case tried today, would have a reasonable doubt. The jury would acquit.
So just the DNA evidence indicates that not necessarily that it's likely that Hobbs did it, but just that it is evidence that it's more likely that Hobbs could have done it, given that hair, than perhaps that Damien could have done it. So the point of bringing it up isn't to say that Hobbs did it, but it's just to say there's more evidence, or one could think it might be more likely that Hobbs would have done it versus Damien, because there's no evidence there at all.
If you have a crime and an eyewitness was able to identify the model of a car seen leaving the crime, and it is a very rare model, very, very few people have it. 1% of the population has it. And it so happens that a suspect, a potential suspect, is one of the relatively few people who have that car, same model, same type, very rare. What prosecutor wouldn't stand up in front of a jury and say, that's a powerful piece of circumstantial evidence? A defense attorney would say it's not conclusive, but it certainly, as part of a mosaic, would be a powerful piece of evidence. And if you accuse someone else of the crime, what defense lawyer would say, they don't have anything that links my guy to the scene, what about the guy who owns that very rare car? And that's what we're talking about here. And as I said before, the last thing as defense lawyers we would intend to do is indict and convict someone beyond a reasonable doubt of this case. The evidence as to Hobbs, even less so as to Jacoby, I don't think should be viewed that way. But is it evidence that would lead any reasonable juror to acquit Damien Echols? Yes, it would. I think we're about at the end of the day. You've been very patient. It's an extraordinary, extraordinary case, and we thank you for the opportunity to bring this information to you today.